Welcome to Cordell and Cordell's Men's Divorce Podcast, moderated by Managing Partner and CEO Scott Trout, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Hey, it's the Men's Divorce Podcast back again with It's the New Year, and it's a great time to talk about New Year's resolutions. I alluded to it at our last podcast where I talked about, we all too often will get a checkup on our car. We'll go get our oil changed, our tire pressure, check the fluid in the windshield washer. Why? Because in the wintertime, sometimes, your car gets dirty, but we don't do it in family law. It's odd, and I've talked about that with tax returns and the 10 stupidest mistakes guys make when facing divorce. We focus more about our tax return during tax season than we do our divorce and anything relative to money we pay or custody or time. And so today we're going to talk about New Year's resolutions. So get some paper out, take some notes. This is a great opportunity to kind of get a checkup. And we're going to talk a little bit about that. And I'm joined from our Colorado partner, Dorothy Ripka. Welcome.
Thanks for having me.
Okay, so let's talk about New Year's resolutions. Kind of what's the whole point? I mean, I alluded to it in my last podcast about maybe now's a good time to get with an attorney and take a review, start planning, right?
Yeah, I think it's interesting. Right now, a hot topic is self-care. People are really into making sure they're doing what's best for themselves and making sure that they're taking good care of themselves, which is amazing. But as you said earlier, I think a lot of people don't think about their divorce decree. Have you looked back and given yourself that same kind of self-care to make sure that what's in place that's affecting your, really your life, your liberty, your children, and of course your finances? Have you taken a look to make sure that that's in your best interests? Yeah. And I think it's a good time to think about it as far as a New Year's resolution goes.
Yeah. I mean, talking about anything self-care, right? I think that is a huge one. We overlook it as attorneys when we're meeting with our clients. We're thinking about the things that we can ourselves try to control, prepare, advise. I've always said, if you look at some of my licenses behind me, and it says attorney and counselor. So you kind of think, okay, I get the attorney part. Counselor is synonymous in some regards, but maybe it's different. Maybe we're here to counsel people, not from a mental health perspective, but maybe the whole body. But again, when we're talking about it, this checkup, it's a good time to think about support obligations, pulling out your agreement. I mean, when's the last time my listeners here have read their divorce decree or their settlement agreement or the judgment? When's the last time you actually read through it? Isn't that a good time to think about it?
Absolutely. I think so many times, I just had this recently, a client who was divorced in 2012 came in and said, well, I have this obligation to maintain X number of dollars of life insurance with my wife as a beneficiary. And I said, you absolutely do not have that obligation. I said, I've just read through it with you. She has that obligation toward you. You have a completely different, much lower obligation. So to his detriment, a 70-year-old man had been carrying this $300,000+ policy because he just hadn't gone back in 10 years and read it. Yeah. And so I think that's where it starts. Look at it. Do you understand it? Do you need to talk to someone to make sure you understand? Have your obligations terminated? Sometimes people realize, oh, wow, I only had to do that for 5 years. I've been doing it for 7. Because you don't go back and think about it because, like most people, you want to put your divorce in a drawer along with your agreement and move on, which is understandable. But at the same time, we want to make sure that we're doing the best things to take care of our clients and ourselves.
Yeah. It's interesting. I don't know if you've ever, Rocket Money. Have you ever heard the app Rocket Money? It's an interesting app, not affiliated, not sponsored. But the point is that sometimes I get an email or an alert, a notification that says, hey, we found a lower price for a subscription. Right. We get in this habit, especially obviously divorced clients get in the habit of, say they have a long-term child support obligation, obviously long-term maintenance obligation. They just pay it. Maybe it's auto withdrawal. And you don't give any thought about it, whether or not it's the right amount. When you think about internet, when I just pay it, maybe I should shop it around. Maybe I should think about, can I lower my bill? I mean, that's what the point is. Mostly a lawyer, I talked about just very briefly in my last podcast. It's worth pulling that agreement out, taking a peek, spending 30 minutes, an hour with a lawyer to review it, because perhaps the maintenance modification is on the table for you. Maybe it's available. So thinking about that, we talked with a number of our attorneys around the country in different states, not yet in Colorado. What is necessary as we kind of morph into that idea of, okay, let's say a maintenance modification or some sort of modification is a potential. What do you do? How does that work? What are the steps?
Sure. It's really important. The main thing that most states are looking for is the significant and continuing change of circumstances. Has something changed since this order was entered? And most likely something has changed majorly if it's been a long time. However, if you're not a lawyer, which most people listening to us today are not, you wouldn't necessarily know that without getting some advice. Hey, does it matter that I got downsized and now I make 3/4 of what I made? Most of the time it does, but maybe it doesn't. It's important to talk to a lawyer. Has something changed with your ex? Now she makes, she was unemployed, she was a homemaker. Now she makes 6 figures. Certainly, those are things that you need to look at. Different states have different ways they determine maintenance as well as child support. And income of the parties is generally the biggest factor to look at and to start thinking about.
Other than child support of interest, I've had a couple questions during our Men's Divorce podcast live, which is, my ex-wife now has a live-in boyfriend. She's intentionally chosen not to remarry because that would trigger a termination of the maintenance obligation. Does that, does his income that is being used to pay household expenses, does that affect my maintenance obligation? That's a big one.
Absolutely, because some states view cohabitation as a right to terminate. Living with someone else can be a right to terminate in certain states. In some states, it's a consideration. And there's also the other point, again, back to pulling out that agreement. Sometimes we contract for that. I've had many clients over my 20 plus years of practicing who said, I want an agreement that says if she cohabitates with someone else who is assisting with payment of the bills, lives in the house, I want a termination. But that termination only happens if someone takes affirmative steps. So again, you could be sitting on this agreement that you've even set your future up with a contract, but if you haven't taken action on it, then you might not realize that. So another reason to read that agreement.
No, 100%. And there may be some, it's very unlikely. I think when it comes to custody, it's more likely you have this mediation requirement before you go back to court. I don't know what Colorado does, whether or not mediation, obviously it's probably a good idea to think about. And there's all kinds of mediation, formal and informal, I always refer to. But what's kind of your thoughts on mediation when it comes to perhaps changing some of these provisions in the new year?
Yeah, there's been a real trend throughout the country, and Colorado is certainly on trend with that, to say we should mediate pretty much anything before taking court time. I think post-COVID, people have realized that a lot can happen outside of the courtroom. So thinking about first, I always tell clients, let's reach out. Maybe opposing party is going to acknowledge, hey, yeah, I did get remarried, or I do have someone else. You can sign a stipulation. It's not an expensive process that way. We call that conferral here in Colorado. If conferral is not successful, then mediation is always a great step, because again, it's something that's less expensive, usually is quicker for the parties involved, saves you the time of trying to get something set in court. And
how long this conferral? How long does this process take? What is it? What does it involve?
So for conferral, it's really just a good faith effort to discuss and negotiate with opposing party prior to a formal process. It's kind of like the informal mediation you referenced, where parties and or counsel can go back and forth and say, look, we think there's been a change. Would you object to us filing a motion to either terminate or decrease the maintenance award? If you can't reach an agreement, then you notify the court, hey, we've conferred, we've tried, now we're going to mediation. But because it protects our clients, we will generally also file a motion to modify at that time, because most states say that the modification can only be effective as of the date of the filing of the motion to modify. So we don't want to take too much time in that conferral and mediation process, or that consideration process, because that can be detrimental to a client. They can lose 1+ months of relief if we don't get something filed. So we kind of always have a parallel track running. We're trying to resolve your case, settle your case, but at the same time, we're also preparing in the event we do need to litigate that your rights are being preserved.
it's easy when we say, pull out the agreement, take a look. With the word of caution, we talked about this in my last podcast of, property is not modifiable. So you take that off the table. But there are a whole host of other things that may be buried into your agreement. It's not uncommon if you're paying alimony, maintenance, spousal support, or even child support to have a life insurance provision where you have to carry a number. Let's just call it 500,000 or whatever that number is. And in some instances, when it's designed, it's set to ensure that the amount of coverage can kind of pay in the event of your death. It'll pay it out to the age of minority or majority. And so obviously, after time, maybe there's an opportunity to reduce it, right?
Absolutely. And I'm so thankful you mentioned that, because so many times clients will say, well, I've pulled out my parenting agreement. And I say, well, what about the separation agreement? Oftentimes there are a lot of things that are modifiable in there. Life insurance is a great example where it may say that your obligation is pursuant to the outstanding amount of maintenance. So if you owed 300,000 to start, but now you only owe 150, your obligation is greatly decreased, which could mean a great decrease in your monthly expense. And so it's really important to look at that, whether or not that obligation is there. And sometimes even life insurance or other obligations relating to kids are in separation agreements, tax exemptions to the extent they exist anymore. And things like that can often be in a separation agreement, or even in a decree, which might be separate from the alternative agreements.
Yeah. And it may be, you live in a state like here in Missouri, where parents are obligated to contribute to the college costs for kids. Obviously to the extent that they can afford it, but the court is going to enter an order and perhaps they didn't do it. And your child is now entering their senior year, the last semester, and that means college is coming up and you're applying and aid is coming in and scholarships. And maybe it's something you want to consider going back, asking for allocation of expenses for college education if it's appropriate in your state. But more importantly, parenting time. That's a big one. A lot of clients will have entered an order where the children were far younger than perhaps the amount of time was based on an age. It's kind of that tender years idea. So maybe it's time to look at parenting time.
Absolutely. I think it's important. And this could even really be a yearly checkup if you have minor children, because looking at whether or not this plan works, as parents, we both know kids' schedules are always changing. Their needs are changing. Your obligations are changing. And it's really important, if you don't have a co-parenting relationship where the two of you can work things out, that you're looking at what's in the best interest of the kids. And most of the time, even if you can work it out, I would recommend putting in place a modification agreement that becomes a court order. Because I've had a lot of parents who say, well, my parenting time used to be every other weekend, but then as the kids got older, we started doing 50-50, but now she's wanting to go back to every other weekend. And guess what? They never put the 50-50 agreement in place. He wasn't planning for the idea that he'd be litigating this, so he hadn't been documenting it. And at that point, it becomes a more difficult fight. Whereas if you had put in place the 50-50 modification at the time you started doing it, then she would be having to modify, because that's the status quo under the court order. So it's also important to not just look at it, but if there are major changes that have occurred since this last order was put in place, consider putting in place that agreed modification order. Now is a great time to do it. If you're in agreement, hey, I'll pay the $500 or whatever it's going to cost a lawyer to do it. I'll take care of that. You don't even have to hire a lawyer. Looks like it's a benevolent on part of the client, but at the same time, it's in their best interest and really the kid's best interest.
Yeah, I think, you think about all of those things. And as you were talking about time and things changing, when you pull out your agreement every year, which I just think is a really good idea, a checkup, right? We go to the dentist every 6 months, perhaps we go to the doctor annually, get a checkup. Right. And this is equally important because buried into your agreement may be a provision that you just forgot about. And a classic example is, I've seen it before, clients were ordered to receive a percentage of their spouse's IRA, pension, retirement, whatever it may be, and their attorney didn't do anything about it. There is a statute of limitations in many states that if you don't take action, I've had it. Someone came to me, their lawyer, not us, failed to do something, and it was 15 years ago. And I said, look, we can try, but if they raise an objection, that's gone. You can renew this judgment in many states. I mean, so there are all kinds of provisions. It's a very wise thing. You put all this money into this investment to get this 25-page separation agreement. Why not just make sure that you're following it? There's nothing you need to do, that there's nothing that needs to be changed. Protect your assets. That's a good thing.
Yeah, and I think that's a really good point as well, is considering whether or not there are enforcement pieces as well. Have you done everything that needs to be done? Did you close that bank account? Did you pay off that, credit card that you were ordered to do? But also, did your spouse comply with those provisions? Is really an important piece, because it is really easy to forget. And unfortunately, as you mentioned, a lot of lawyers and clients think, well, we got to the goal line, we finished the case, they're divorced, the agreement's in, I'm closing their file. Well, as we both know, there's a lot that goes into post-decree, making sure clients, agreements are executed, whether it's a quitclaim deed, whether it's a division of a retirement account. And those things are often missed by both clients and lawyers. So it's really important to do that checkup as well.
Yeah, I agree. And so I think it's getting in the habit of doing it. I know you don't want to go back and relive the trauma of going through a divorce. It's expensive. It's mentally tolling. It's physically tolling, and there's no winners. Everybody walks away with less. So I think it's a good point. And thanks for joining today to talk a lot about it, Dorothy. Appreciate it.
Appreciate it. Thanks for having me.
Yeah, and annual checkup. Write it down. Get it done. You can call us. You can schedule an appointment for that annual checkup. You can go online. You don't even have to call. You can schedule an appointment at Cordell.com. You can enter your zip code, your address. It'll tell you the office closest to you. Pick a date, pick a time. You don't even have to talk to anyone if you need it. I love it. I like scheduling online. It's quick, it's fast. I don't have to wait on hold. Go through a calendar. I can do it right there. But if you're old school, you can pick up the phone and give us a call, 866-DADS-LAW. Obviously, we do consults just like this, via Zoom, via Teams, internet, phone, in person, whatever is most convenient for you. Don't forget to check out our Men's Divorce podcast live. That is a live segment where you can log on, ask questions live of a panel of Cordell attorneys to get answers right then and right there. It's free. You just have to register. So you can find that on all of our social media accounts as well as Cordell.com. Don't forget to check out our YouTube channel and, of course, subscribe to this podcast. You get alerted every time we drop a new one. So until next time, have a great week.